Following the announcement of the Northern Territory emergency response, the Commonwealth decided to intervene more directly into the treatment of Aboriginal customary law in the Northern Territory courts. Now, as you can imagine, there's been a debate about the status of customary law, how the courts should deal with customary law, whether customary law should have a status alongside the general court system, be permitted to deal with certain issues entirely independently of the general court system for many years. And at some point, I think probably during the 1990s, maybe the early 2000s, while the sunlight of the Mabo case perhaps still shone, there seemed to be some possibility that legislation might be enacted in the Territory that would give some status along those lines to customary law. And I mean something beyond the Koori court system in the sense of, as good as that may be, but there's no transfer of power, put it that way, in the Koori court system. So there might be perhaps some possibility of a certain amount of transfer of power. Instead of that, following the emergency response, we have Section 91 of the Emergency Response Act, which says that, if you can read it, you probably can't, a court in the Territory is not permitted to take into account customary law or cultural practice as a reason for excusing, justifying or lessening the seriousness of an offence or aggravating an offence. And there's a similar provision in Section 90 in relation to bail. The courts are not allowed to take these things into account. What sort of situations was it designed to deal with? Well, if you're going to put forward an argument for that type of legislation, and I'm not, but a case like Queen and Wonnamurra in 2009, again, a man from a traditional community, I think it was northeast Arnhem Land, had announced his intention to plead guilty to assault-related offences committed on his wife, or customary law wife. And there was evidence that he had said that he was acting in accordance with traditional Aboriginal law in some way, and that therefore his moral culpability for the offence was lessened. Now, how is the court going to deal with that? Well, this issue has come up a few times. The judge said that it was clear from Section 91 that the long-established sentencing practices in the Northern Territory, whereby this assertion from this man could be tested and taken into account in whatever way the court might think appropriate, in conjunction with other evidence from the woman, for example, or from other community members, in arriving at an appropriate sentence, that those well-established sentencing practices could no longer apply. The court cannot take customary law or cultural practice into account for the purpose of lessening the seriousness of the criminal behaviour. Is that fair enough? Some people, I'm sure, would argue that it is. First thing is, well, a court would take these things into account in sentencing anybody from any other community in Australia, a man who had bashed up his wife. Why not take the man's beliefs into account in whatever way as a sentencing judge you would think appropriate in looking at an Aboriginal man who's pleading guilty to this type of behaviour? It's true that many people would argue that no court should reduce a violent man's sentence on the basis that he was acting according to customary law. Have the courts done that? Have the Territory courts ever done that? Certainly it's been put out in the media at various times that the courts have done that. I think that there's very little, if any, evidence that the courts do. And in the occasional cases where it has occurred, there's been huge media publicity to a few cases coming out of the Territory 4 or 5 years ago. Some of you would probably know about these cases. Sentences are usually increased on appeal. In any case, there's a difference between saying courts should be wary of reducing sentences because of customary law and saying that courts are forbidden to take it into account in the first place at all. But let's just put that debate aside for a second. That section 91 that was up there a second ago has some unintended effects. Well, I think they were unintended, I don't know. But I assume that this section was intended to deal with a kind of Warramurra situation. There was another case late last year. Aboriginal Areas Protection Authority, essentially the body in the territory that administers the sacred sites legislation. And what had happened was that a construction company out in the remote area had constructed a pit toilet for the use of its workers on an Aboriginal sacred site. Now, it had done that unknowingly. They didn't know, they needed somewhere, you can imagine the situation, they didn't realise. They pleaded guilty to a charge. They did remove the offending items as soon as they became aware of that, and they did apologise and so on. So it had to be worked out, this mistake, by a process of negotiation, I suppose. But they did plead guilty to a charge of carrying out work on a sacred site contrary to the relevant section of the Sacred Sites Act in the NT. There was an appeal against the inadequacy of the sentence. Sacred Sites Authority, the custodians, were unhappy with the sentence and they thought it should have been greater. And they argued that the sentencing court had failed to give sufficient weight to the damage to the site in the eyes of the traditional owners. They'd failed to take into account customary law, the customary law view of how serious an offence this was. However, after legal argument, the appellant had to withdraw that contention. They had to accept that under Section 91 of this Emergency Response Act, a court cannot take into account any form of customary law as a reason for aggravating the seriousness of an offence. In other words, take the legalese out of it for a second. We're talking about desecrating a sacred site. And in deciding what's the penalty for that, courts are not allowed to look at the views of the custodians under customary law. Now, what's the Sacred Sites Act for? Why is it there? It seems paradoxical and perverse. I hardly need to spell it out. And clearly to frustrate the very purpose that's intended to be served by legislation of this type. Did the legislature here consider that this might be an effect of Section 91? Well, we were told, Paul said before, Mal Brough didn't actually read it. I don't know, would he have thought of it if he had read the legislation? We all know that it was rushed through. That's one effect. Potentially, it jeopardises other practices in the Territory at a lower court level. Northern Territory courts do routinely take customary law into account. They have, a little bit like the Koori courts type system we've got here. Community courts do sit. The Court of Summary Jurisdiction sits as a community court at various remote locations throughout the Territory, the top end in Central Australia, and essentially inviting community participation from Aboriginal people. Input into the court process, people are encouraged to have their say, including, of course, on sentencing matters. Does it say anywhere in any legislation the Territory courts, these courts are set up? No, it doesn't. There's a section of the Territory Sentencing Act that provides a process by which courts can receive information about customary law. And it's pretty much unanimously accepted, I think, in the Territory that, this is a good thing. That when your white fella court, your barristers and your lawyers go, judges and magistrates mostly, go lock, stock and barrel out to a community, that they should actually listen to what the community has to say about an offence. And yet, potentially, this section may jeopardise, perhaps, practices like that. And again, I don't know whether Mal Brough or his mates thought about that. So, thinking for how to wind this up, about how should we finish? Is there an optimistic note on which to finish? I think it's better actually not to hear from me on this question about what the courts should do, how the legislature should deal with customary law, and I'd rather prefer to turn to the words of a traditional Aboriginal woman, Bess Nungarai Price, for some words about this difficult issue. I think that's there on the PowerPoint. Our problem, she says, is we want to keep our culture. We want to respect our ancestors and their law. We also want to be equal citizens and we want human rights. We can't do that without changing our law, but we need to change it ourselves. Others can't do it for us. Only we can solve our own problems and we can do it in our own way. But we need the support of governments and our fellow citizens. You need to listen to the voices that are usually drowned out by the strong, the noisy and the powerful. You need to find a way to listen to those who don't speak English, who are the most marginalised and victimised in our own communities. You need to listen to our women and young people, the ones who don't have a voice. If you really want us to have human rights, you have to find ways to protect the victims of black crime as well as of white crime. Thank you.